So, Philip, we have this current case, Kennedy versus Bremerton School District. Tell us about it.
Yeah, the current case comes from the state of Washington, actually my home state, and it's a little bit complicated. The facts are there's some disagreement among the parties on the relevant facts, but in its essence, to simplify somewhat, high school football coach prays after the game on the 50-yard line. I think, if my memory is correct, he started the practice alone, and then some players started joining him. Players on the other team started joining him. This went on for several years, and then I got some publicity, and the local school district said, "Look, you just can't do this. We don't want we the school district don't want to be seen as endorsing religion, which is a constitutional violation, at least under some Supreme Court precedents." So they told him to go pray in the press box or wait till all the kids leave and leave the stadium. And he made a stink about it. And lawsuits were filed, and now we're writing about it in First Things.
So the case then, review for our listeners what the judges have to make a decision about whether this has to do with the establishment of religion. There's something. Explain to me why this would be even relevant as a constitutional matter.
Sure.
Like a guy, football coach, it just seems so remote from the First Amendment and its prohibition against the establishment of religion and its vindication of our right of free exercise.
Yeah, let me just say your instincts seem to me exactly right. How did we get from the government making one church the official church of a state or the United States to a local school district official telling a high school football coach, "Look, you can't pray for 20 seconds after a game." The disconnect is palpable, and I suppose that's why we're talking about this. Something has gone wrong. What that something is might take a long time to explain, but there are three main precedents. One of the problems with the Court's Establishment Clause jurisprudence is that there are all sorts of precedents, not just one precedent. There's something called the Lemon test. That's a name for a case in the 70s called Lemon v. Kurtzman. And according to the Lemon test, a government must have a secular purpose when it acts. It cannot advance religion, and it cannot entangle itself with religion. That's a court-made doctrine to enforce the First Amendment's prohibition on Congress making laws respecting an establishment of religion. Justice O'Connor in the 80s modified the Lemon test. She proposed that the court use instead what's called the endorsement test, and that's simply the idea that government cannot endorse religion. That precedent was criticized by Justice Kennedy, who proposed his own test. Sometimes goes by the name the psychological coercion test. The key idea here is government cannot coerce religion, but Justice Kennedy had a broad notion of coercion, including psychological coercion. So in the context of schools, which is the context of the current case, public high schools, psychological coercion, according to Justice Kennedy and a majority of the Supreme Court, includes students feeling in any way pressured to pray.
In any way. I find
that
really is a test that you can never succeed with that test. Well, I guess coercion is in the eye of the beholder.
Exactly. So the actual facts of the case were it's actually a middle school graduation, and kids at the graduation, which wasn't even mandatory, were asked to stand while a local member of the community said a benediction. And the mere act of this prayer being said in the student's presence at a voluntary graduation ceremony was deemed to be psychological coercion of students.
As you put it, this way of thinking winds up treating any religious expression as like a contagious virus.
Yeah, which you can't expose students to.
Well, okay, so give us what do you want to see written into this majority opinion?
Yeah, well, it's not really what I want to see. What I try to do is say, look, if you're really going to follow the founders' political philosophy, this is what the type of jurisprudence you'd get. These are the types of tests you'd get. Um, First, you'd say the state can't delegate its authority to churches,
Hmm.
right? That's sort of a core principle of non-delegation, or really it's called subdelegation. Um, uh,
So to go back to the South Carolina case, the state certainly cannot delegate its taxing authority.
the state cannot delegate its taxing authority to churches. And there's actually one modern case. Um, it's called Grendel's Den. And in some ways it's sensible, but it's an improper delegation. If you wanted a liquor license in Massachusetts, I think this was actually in Cambridge, Massachusetts, um, and you were within, I can't remember how many feet of a church, 500 feet or something like that, the church could effectively veto the liquor license. But the
Right.
law said if the church vetoes, then you don't get your liquor license, effectively delegating the state's power of licensing to churches. So you couldn't do that either.
And so no delegation. Any other elements that you think are important?
Yes, and then no, the state can't function like a church. So the state can't write articles of faith. The state can't tell churches how they are to select their ministers. Uh, this is, we might disagree here. The state can't write prayers for students. And if you push the principle, and I know a lot of my friends won't like this, the state can't appoint and pay for its own religious ministers. So
Right.
congressional and military chaplains. I mean, that's a little controversial, but I actually think that's the consequence of the
So
principle.
the basic idea here is that the test is is the church acting like the state, and the other contrary side of it is the state acting like a church, and
Yes,
and,
yes,
and that's
basically,
what.
yes. Yeah.
So if you want to say separation of church and state, that that would be a way of, as opposed to this notion that, I mean, it's normal for the state to subsidize uh, pro-social behavior. And so if the Alcoholic Anonymous meetings are being held at the church, and run by the church, and in fact, we do allow public funding of these sorts of activities.
And the
Often
real,
social services that are provided by churches that serve the public good are, the state signs off. I mean, the court perfectly signs off on the idea that, the Catholic Church gets a lot of money from various government agencies to provide social services.
yeah, and the state's interest is, does your AA program work? And if it works, then it's in the state's interest and competence to fund it.